Good afternoon. I'm not sure how many people are coming. I know that we've had a very large number sign up, but I suspect people will join as we start talking. We thought we'll start now because this is your precious time for normally lunch or other things. Just to remind everybody that the session that we're about to do is being recorded. We've said that we'll try to answer as many questions and answers from the chat as possible, because obviously this has generated a lot that is moot for discussion. But what we've agreed, Tor and I, is that if there are really so many questions, we will just do a short little webinar or little podcast effectively, and we'll just send that out to you afterwards with answers to the questions we can't cover. Don't worry if some of the slides are slightly too wordy and you can't read all of them at the same time, because we will also have all the slides up on the website for you to be able to read at your leisure. So I'm Susan Rodway, and I was counsel for the claimant in both of these important judgments, the first being the one of Mrs. Justice Lambert, which was decided in December 2020, and the second one being the one that has really, I think, generated the news because the story came with it, which was the trial on the facts in front of Her Honour Judge Coe, which has only just recently happened this month. And the judgment, as we all know, went in favour of the claimant on the preliminary issue, which we'll talk about, and in favour of the claimant on the facts. And it is my hunch, I say no more than this, that if in fact this had just been left as the preliminary issue, the lawyers would have been very interested, but the general public and certainly many of the doctors, I think it would have gone under the radar. But we've had the trial on the facts, and of course, Evie Toombes herself is a very attractive person and a personality in her own right, and I think all of that, together, as we will show you with some slightly misleading headlines, has caused perhaps a little bit of a storm, and we hope it's in a teacup. So as I say, I'm Susan. Victoria is going to introduce herself and explain why she comes along to give her input into this.
Susan, yes, so I'm the sort of interloper here because I'm not a clinical negligence lawyer. And the reason I'm here is really, firstly, that I spend too much time on Twitter. And so when the judgment came out, I saw a lot of discussion about the case on Twitter. And one of the things that I am interested in is public understanding of legal judgments and how to convey legal decisions to non-lawyers. Twitter is better than nothing for doing that, but it's not ideal. And I'm always on the lookout for cases that have generated interest, where it would be helpful for people like Susan to actually do a seminar like this and explain them in a bit more detail, and also give people the opportunity to ask questions. So I'm here sort of in the role of the person who finds it all very interesting but isn't the expert, and I will be mainly fielding the questions that come in on the Q&A box and demanding that Susan answer them. So do fill them up with all your trickiest questions.
Right. Well, look, let's introduce you to the issues as I think generated by public and the medical profession on Twitter. So if we just go through a couple of the next slides, these are directly taken from the medical discussions. Not all of them are from doctors. Some of them are members of the general public. You can see the first one. The implication her child should not have been born impacts on all of us who are disabled. This is a theme that I've also picked up via the social media channels. That those who are disabled take great offence to this judgment, and we'll discuss that later. And the second tweet, I think, really encapsulates what a lot of the medical profession are feeling about this. It should worry you. Is this person, this was a doctor in fact, that a GP could be held liable for the fact that a child with a disability was brought into existence is horrifying. And again, we'll discuss that because I'm afraid that's been the law for a very long time. So if we just look at the next couple of slides, we'll see this is another strand of concern. Folic acid doesn't prevent 100% of cases, warned as a risk if not taken, etc. Again, we'll deal with that because this is a common misconception. This ended up being a case that was nothing to do with whether folic acid, if taken by this mother, would have prevented spina bifida in this claimant. And the issue, therefore, it removes itself from that scientific inquiry. But we'll deal with that because obviously the way that the case is put means that it could have been advice about something different rather than folic acid. And this is, I think, very much, again, the sort of, I think Tor calls this the righteous indignation. And this encapsulates the sort of flavor of many of the tweets that I read. The judge in this case is wrong, out of order, and unfit to judge. Hope this judgment is overturned at appeal. Shame on the parents who brought this case and on those who advised them to do so. And just as a little side issue here, this rather shows, to my mind, some of the nastier sides of social media, because I know that not only the claimant, but her family have been quite nastily trolled on social media. She's a pretty available person, and so people have been able to get to her and say some pretty cruel and evil things. And even I have not been immune. People, because my email is readily available, I've had a number of very interesting emails, and I know that my instructing solicitor has also had the same treatment. So it's interesting that there is that sort of venom out there. And that's also the reason why we really want to try and be more rational and reasoned in this webinar and discuss with you what we consider to be the real issues in the case, without that sort of passion, and certainly without that sort of, I think, unkind and unfair comment. And then the final tweet that I think is very much what people are thinking is this ruling will bring the NHS to its knees. Well, that is something we very much need to consider as we go through. So let's just go back to the first basics and identify what it is that we're here to talk about. I'm sure that most of you who are in the audience today know the facts of this case because you're sufficiently interested to give up 45 minutes to an hour of your time to listen to us talk about it. So these are the very basic facts that I've just set out there. I'm not going to read them out because you can see that it was a historic case. 27th of February 2001 is the relevant consultation, a consultation specifically to discuss preconception advice. And there's the advice that was given, and conception occurred almost immediately, really. I mean, all the dates showed it was virtually as soon as the conception advice had been given. And then we find the claimant born 9 months later with lipomeningoceal, which is a form of spina bifida. So if we look at then the next slide, which deals with the preliminary legal issues, these are perhaps the important ones to highlight. This action was brought by the claimant, and that's probably one of the first interesting issues, because it's not a claim that was brought by parents. So it's not a claim for wrongful birth. And that, as we know, normally brings with it, the wrongful birth claims are normally those cases where it is said that the disability could and should have been identified antenatally, and the parents then say that if that had been the case, they would have opted for a termination. So that was not the suggestion in this case. First of all, it wasn't. It was investigated and it was accepted that there was really no way that this particular disability could have been picked up antenatally. So that is not part of the discussion. There was never any allegation concerning termination at all. And certainly the claimant herself has never said, I should have been terminated. And if she had said that, if that was the case, I'm afraid it would have faltered at the first hurdle, because there is a case of those lawyers amongst called Mackay, which has been decided many, many years ago, which does not allow a claim for wrongful life, which is what that would be. So no claim for wrongful life could be in any way brought in this case. So if we then just go on to the next one slide.
Yeah, just before we do,
yes.
So could her parents have brought their own claim instead of her?
Yes, I think they could. It's an interesting one that I haven't explored with them. I think that the reason that they didn't bring the claim is that I think, tied it in with this idea of termination, and they didn't at any stage ever say, we don't want Evie. Evie's an absolutely fantastic daughter. So there was an emotional element, I think, there. And time, I think, also went against them, because by the time they really started thinking about it, issues of limitation were coming into the picture. So by the time the case came, certainly to me, it was only the claimant who could bring an action on her own behalf, because she was at that stage still under the age of 18. And again, one knows in common law, personal injury actions, negligence actions, there is a preliminary period of 3 years, but it's extendable if you're underage. So it only runs from the majority age 18 and can be extendable in other circumstances. So I think it could have been, I think, brought as a claim for wrongful life. Probably, however, would have ended up having the same issues.
Yeah.
Because you wouldn't, as we come back to it and we go through this, it wouldn't have been a claim where they could have said it should have been identified. So it would have been right back to the same issue.
Yes. So there weren't any other cases before this where a parent had tried to bring the same sort of claim based on the timing of the conception.
I'm not aware of any. There are some cases. There was an Irish case. There are some cases dealing with IVF issues, and also some very interesting cases about various types of genetic disabilities that should have been known. But this, I will be corrected if I'm wrong. You can imagine that in my research, I did a vast amount. I went all over the world looking at these sorts of claims, the States, Canada, Australia, Holland. There was the case in Holland, which we cited in the preliminary, and I couldn't find anything that was on all fours. So I think this is the first time it's been framed in this way.
Brilliant. All right, next slide then.
So this is the way it was framed. And again, I'm going to go through this very quickly because the issues, I think, are extremely familiar to those of you who are lawyers or who read the judgment. So it was primarily based upon the negligent advice given by Dr. Mitchell to the claimant's mother. All right. And the chain there was, we said, cause of action between claimant and Dr. Mitchell, had to establish that. Breach of duty to the claimant by giving negligent advice. Claim crystallizes on delivery of claimant in a live state. So there wouldn't have been a claim if she died in utero or anything of that sort, for obvious reasons. She wouldn't have been a person. So as soon as she's born, that claim it is made up because she's born damaged. So we've got all the ingredients required for a tort claim. What would have happened? You have to then balance it. Okay, that's the consequences of what in fact happened. Negligent advice given, child born disabled. Here, I think the real interest in this case is what would have happened if the non-negligent advice, if the correct advice had been given, and the argument, obviously at this stage we hadn't proved it, it was based upon assumed facts, but we argued that would have led to a delay in conceiving. And that then brings us into this very ethical, moral, and difficult dilemma, because there's no way, obviously I as counsel, everyone has to accept that a delayed conception would have meant that the child that would have been born would have been a genetically different individual.
Yeah, and that's the sort of weird bit about the case, I think, if you're not someone in this area, is that we're sort of familiar with the idea that a health professional gives some advice or does something which causes harm to this particular person. But here, the causation is sort of separated out, because actually nothing that the doctor did here had any effect on the claimant, except that if the doctor had done something differently, she would never have been born. And I think that's where the sort of lay person, if you like, view, when you come to it, you sort of think, well, that's sort of weird, because you then are sort of saying, you know, I'm really cross with you for having done something that means that I exist. And that's where you get into the kind of philosophical stuff about, well, how can you possibly complain about existing when the alternative is never having been born?
Correct, absolutely. And that's the tension, because it's the argument between people, the word existing, as opposed to being born with a disability. And so the focus has crossed over, certainly in the media and in the discussions that I've read. The focus is wrongly been lasered onto this idea that I should not have existed, which is not what was being said. It was, as a matter of fact, this is what would have happened, but forget that, because the court looks at what has happened. Yeah. And what has happened is, quite simply, a disabled child has been born.
Yeah. And your last, I think, bullet point here about the defendant agreed that if conception had been delayed, then on the balance probabilities, the mother would have had a child who didn't have any disabilities. Yes. And there's a question that's been asked, well, you know, given that there's a risk for all of us that any baby that we have could have a disability of some sort, why did the defendant agree that and not try and argue that, you know, you couldn't be sure that the person that was born at a later date would have had nothing wrong with them?
That's because of, again, the precise facts of this case. It's because this was a spina bifida case. And if you look at the data with regard to spina bifida, you're already below 50% likely, even in an unfolic acid prepared case. It's a relatively rare complication. Yeah. And so this is again where the medical world and the lay world and the legal world clash, because it's this concept of balance of probabilities. So is it more likely than not? And broadly, we use that 50% bar. So if it's under 50% likely that the next pregnancy would have been one with spina bifida, the defendants were forced to have to agree that statistically, on balance of probability, a later birth would have been normal. And we'll canter over a slide that covers this later, because I'm covering it now. But there was genetic testing and investigations carried out. It wasn't the form of disability that was due to any genetic component in the parents. So it was just a stochastical one-off.
It's quite interesting, isn't it? Because I'm obviously not a doctor, but you can imagine that it might be pretty unlikely for someone to be a person where any pregnancy has a more than 50% chance of resulting in a child with a disability. I'm just sort of thinking, you know, even things like cystic fibrosis, which, you know, there's a clear genetic pathway. You're not tough at, you know, the more than 50% likely.
I agree.
You'd be pretty rare for someone to be able to say, well, any child you would have had would be 51% or more likely to be disabled.
To have this disability. Yeah, I agree. So that's perhaps a worry, isn't it? That's probably where the medical profession becomes concerned because of this point. All I can say is I haven't seen this happening beforehand. And when we get to the detail of the Act, we see the Act's been around since 1976. And if it's not been employed in that way. So I'm trying to think of a situation, no doubt in the chat and the questions, someone clever in the audience will think of a situation that's analogous, that would not include prenatal identification of the disability. Because if you have an opportunity for antenatal identification, you're back into the slightly different issues of we would have terminated and that would have been wrongful. And it has to then be brought by the parents.
Yeah, so there's
The
quite
claimant
a
can't
narrow
bring a
set of
case.
facts.
Exactly. The claimant can't say, I should have been terminated.
Yes.
That is
So,
repugnant to the law.
yes. And so I suppose, is it that the judgment is really only going to apply to disabilities that are sufficiently impactful on someone's life that they might want to think about bringing a claim, but not so severe that they would be picked up antenatally or could
Correct.
be picked up antenatally?
Correct.
That might be a relatively small class of
Absolutely.
of
And then where is that? How is that caused by negligence?
Yeah.
You know, another protection for the doctor, because there's going to be very narrow instances that are going to conform to this.
Yeah.
I'm
distracting you from your slides completely. We should press on to the next one, shouldn't we?
Okay, right. Okay, because everyone's going to want to. Right, let's move on then. So that was the issues that were, and I think now we've just covered this one. I think that's what we've just been talking about. So one point that I hadn't made clear is that there was also factual evidence that after Evie had been born, the parents went on to have a healthy child, her brother. So that we had a factual point as well to say, look, as a matter of fact, a later conception was healthy, etc. So the first trial, and I'm going to just pick out some points here because it is important that people understand it, but I'm trying not to let you all fall asleep during this. But this is the act that we were really focusing on when we had to address the point raised by the defendant. This was actually a wrongful life claim, right? This was effectively.
And this is an act that came out of a huge amount of pre-act thought about how to deal with all of this. So that, yes. I think sometimes on Twitter you sort of feel, gosh, a judge has just out of the blue come out with some judgment that they've just made up. But actually there's not only an act of Parliament, but also a whole load of...
Oh, the Law Commission. And if you read the Lambert judgment, she deals with it. There was, it was virtually, we were thinking this was a Supreme Court point. And so the research done on both sides was absolutely voluminous. And we got all of the Hansard transcripts and the relevant Law Commission reports. And you got a flavour which we were able to get across, but encapsulated, frankly, in this, which is the preamble to the Act, simply saying it's an act to make provision for civil liability in case of children born disabled in consequence of someone's fault. And what we really think that the Act originally was focusing on was very much birth injuries. You know, so the statutes needed to be clear that if a child was born with, you know, some sort of hypoxic injury due to negligence, that needed to be clearly defined within statutory law so that it avoided a lot of the arguments that were being made around that time. So that was the genesis, as it were, of the Congenital Disability Civil Liability Act. By the way, this is the hazard, I'm afraid. I've just decided I'm not even going to fight it. I apologise to everyone for the additional attendant of my dog who's sitting beside me. She'll be quiet, though, otherwise she would be thrown out. So I've just highlighted here, this is just section 1 of the Act, and this is really all that the analysis in that first trial dealt with. So a child born disabled, result of occurrence before its birth, and a person, other than the parent, mother, is answerable in respect to the child's disabilities, then the damage resulting from the wrongful act of that person is actionable at the suit of the child. So it gave the child the opportunity, and this obviously overcame the problem I was talking about earlier with the wrongful birth cases where there was a time limit. So a child could now bring an action. So let's say it's a cerebral palsy case. That now gave the child the right of action in its own right, his or her own right, rather than the parents. And therefore you had then got, because a lot of these cases, the child had to grow up and realize, hang on, I want to claim for this. So that's the section 1. If we then just go on to the next slide, we can see what the next issue was, what is an occurrence? And it's very simply defined. Occurrence, one which affected either parent or child in their ability to have a normal, healthy child. So you can begin to see how that was readily applicable in situations to do with something negligent happening during delivery, for example, but was not so easily applied to the circumstances of this case. So that was the quote. We can go to the next slide, because that's just telling us the background to Lambert J. And this is what she decided. She said, claimant's born disabled. The main thing that was very clever of her, and I give her the credit, not anything on my side, was that the occurrence was sexual intercourse prior to conception. That's the occurrence. So that's what shifted it into this realm. And then D, answerable to C, and hence C's disability actionable. So she really, as all very clever people do, simplified it and presented it in a way. We'll get on to the next point, which is why didn't the defendants appeal that? And I think that's the defendants are going to have to answer for that. I mean, I suppose I'll just hazard this as a guess, I suppose there's an argument, as I said earlier, that if they just kept stum, we know it's a first instance judgment, it can potentially be addressed again in future cases, and another judge can come to a different conclusion, and it keeps it slightly under the radar. But it doesn't naturally fit with the subsequent decision to have a trial on the facts, which is obviously going to be the point at which the media becomes interested.
Yeah, so because Lambert's decision was back in 2020.
Correct.
And that's the decision that I think people are potentially objecting to, the idea that this claim could have been brought at all, and saying, well, I hope the doctor appeals, but it's too late to appeal that decision because that was back in 2020. Yes. So that decision just stands now. But as you say, another High Court judge could look at a claim by someone else that's similar and potentially reach a different decision.
Absolutely, not bound at all by the decision because it's a first instance decision.
Yeah. And have there been any other cases that you know of since that 2020 judgment?
No, and it did get some, it had some notoriety, probably primarily amongst the legal fraternity, but enough for it to get out there and for, I assume, a large cohort of claimant solicitors to be aware of it. But I will be corrected if I'm wrong again, because things may be happening that I'm not aware of. But
yeah. So in answer to your question on this slide, it was novel back in 2020 when that part of the case was dealt with, because it was the first time anyone had really looked at the Act in any detail in this sort of scenario, where what you're talking about is a change that would have meant a change in the timing of conception, not anything to do with the child themselves not having been disabled.
Correct. So it's a novel application of an historic act, which we see from time to time. And yes, perhaps you can blame the lawyers that sometimes we see a way through, but it's actually been there all the time.
Yeah,
ironically. So yes. So then this is. I think we've sort of covered this tour to some extent. This is perhaps the most heartfelt of what I call the misunderstandings, and the one I desperately wish to get across as being just plain wrong, because it's not, no one, the parents nor Evie, none of them say themselves, I should not have been born. And that is that, as you say, we're back to that ethical conundrum, because it's the legal formulation that inevitably leads to the conclusion that if she had not been born, another person would have.
Yeah.
And it's a distinction that does have a difference and is very important. So the headlines, and we know what reporters do. It certainly sold newspapers. That reporter, who was a reporter sitting in court, that's not a quote that ever came from anyone on the claimant side. That was a quote that I think has been lifted out of some of the points made by the defendant and slightly twisted.
Yeah.
But not, please, everyone listening to this, it's not what the claimant says. She is the most incredible. If you read Her Honour Judge Coe's judgment, she really is the most incredible young woman. She has never let this very, very all-consuming disability in any way hamper her. And when you see her, well, she can't feel properly below her legs, and she can't feel her legs below her waist properly. She's doubly incontinent. She has to be tube fed. So she's literally takes a backpack with her. And what she has done in the world of show jumping is just quite incredible. It'd be incredible for a completely able-bodied person, let alone someone with her disability. And that's what she says, find a way, not an excuse. So I do have to advocate strongly here that she is not saying she should not have been born.
Yeah. And it's really difficult, isn't it? Because she's obviously able to sort of separate those two things out and say, well, I'm not saying I shouldn't have been born, but I am saying that the world should have been differently arranged and my mother should have not conceived me. Right. And that she's able to sort of separate those two things. But I can see people saying, well, I don't really think you can separate those two things, because fundamentally, when it comes to the legal claim, you are effectively saying, I shouldn't be here. And it's when Lambert looked back at the Law Commission and all of that, it's sort of surprising, I think, when you don't know much about this, to look at it and think, well, didn't they think of this? They must have realised that there could be negligence pre-conception, and that this might have been a possibility.
Indeed. I mean, they did consider that. That is one of the things that they thought about it. But I think, you know, we were in the very, back in 76, I'm trying to think when Dolly the sheep and cloning and things and IVF, well, doctors will know. I think
that's the 90s.
They were very much scientific novelties, weren't they?
Yeah.
You can't really expect these sorts of issues to have been in the forefront of members of Parliament.
No.
Who were clearly being advised, but by a law commission. There wasn't a great deal, as far as I could find, of medical input in relation to this, although they were part of.
No. And did Lambert sort of take the view, well, you know, if it's clearly ruled out on the face of the statute, then you can't do it. But if it's not clearly excluded, then we can't really assume that Parliament meant that this sort of claim shouldn't proceed.
No, absolutely. That's precisely what she said. So there we go. Right, and then. I think this speaks for itself. I've just thrown out there sort of negligence in IVF. That does, it's sort of, once you say there's a negligent, the wrong gamete or something has been used, and that somehow does not seem to offend moral justice as much as this case, although the eventual argument is identical, that the disabled child is not the one that should have been born.
Yeah, it's interesting, isn't it? When you look at the sort of public policy reasons that were given and which Lambert accepted about why you shouldn't be allowed to argue that you should have been terminated, they're really obvious, because you couldn't, it is offensive to suggest that a doctor would have a duty to say to a mother, you need to have a termination because your child's got a disability. Like, that you can absolutely see those public policy considerations and why they led to that conclusion. It's
put the other way as well, because it's put very strongly. And of course, in Mackay, which is the 80s, there was a very strong feeling of the sanctity of life. So it was very much put from that slightly reverse issue that all life is sacred.
Yeah.
Which is, any child born with any disability is still a precious living being, which is exactly contrary to what people think that this case is saying. I mean, it preserves that, because it doesn't in any way upset the idea that life is precious.
Yeah. Okay, next slide.
Now, this is the good news. Not promulgated widely at all, but this is what's built into the Act. So I know that anecdotally, I'm aware that there are, I think there may even be in the listening groups today, but there are certainly numbers of doctors who are very concerned about, for example, prenatal advice to psychiatric patients with regard to the medications that they are taking, and or patients who present already pregnant, should they stop their medications, or are they going to be teratogenic? And here we have two defenses that I just think is important. So the first of them is in the case of recurrence preceding the time of conception, defendant is not answerable to the child if at that time either or both parents knew the risk of their child being born disabled and ran it. Do you see?
Yeah.
Because that's the bit that isn't said there, but they knew there was a risk. So both parents, it's quite difficult to see this in the context of this case, but effectively the doctor says, well, look, your child's going to be born disabled because you've got a very high genetic probability, and they go ahead. There's no action that then can be brought by the claimant.
What if the doctor says you've got a 60% chance of this disability occurring, and actually the correct answer was that 80% chance? You know, is that the sort of thing?
Where are we then? We're then back into the Supreme Court decisions, aren't we, as to balance the probabilities and percentages and all the claims in relation to failures to diagnose various forms of cancer, for example. You know, you've now got an X% chance of surviving 5 years, whereas you would have had a Y%. And it descends seriously into angels on a pinhead at that point.
Yeah.
It seems to me, put simply, the Court of Appeal and the House of Lords and the Supreme Court will go with it if they can identify that it's something that's more than 50%. But if it's in the realm of, oh, there's only a 10% difference in the risk, they won't go with it.
And I suppose actually it's probably quite difficult. It could be quite difficult to persuade a judge that although you were happy to take a 60% risk, you wouldn't have been happy to take 80% one. And so actually a lot of these will come back to the factual sort of scenario.
And you'll also be back into the realm of the termination scenario. So, you know, for example, cases of Down syndrome that are not picked up on a nuchal test, or are wrongly picked up, or are said to be not existing when they are. That is always going to be a case, in my view, where the parents are going to be saying, you know, we would have terminated if we'd known.
Yeah, and so that's not going to happen. Okay.
Second defence, probably more important, under Section 5. So this, I think, really does cover the difficult situation that I was talking about with the prenatal advice for potentially teratogenic medication, not answerable to the child. Anything done or admitted to do for advising the parent if the practitioner took reasonable care, having due regard to then receive professional opinion. So you have to go to the time, it's time relevant, applicable to the particular class of case. So it's potentially, I mean, it's really no more nor less, is it, than do your job well, do it within the parameters, as long as you take reasonable.
And again, is that another sort of unusual potentially feature of this case, which was that it was really very clear that you should take folic acid to avoid some forms of spina bifida, whereas in other scenarios, there might not be very good evidence about whether there's a risk of being on a particular medication at the time that you conceive.
Well, I think to put it into this context, I think this case comes completely separately, because folic acid, the judge accepted this. There was no evidence, let's put it this, of any significant adverse effects of taking folic acid.
Yeah.
So there's no harm, so why not do it is part of the argument there. And indeed, mother took a very, very, very high dose for a very long time prior to conceiving her second child. But that's not really, I think, what this section is saying. This section is really a sort of Bolam defense, isn't it? It's a sort of, if you've done what is reasonably considered to be appropriate in the circumstances and in accordance with the accepted wisdom of the day, then look at the second part that I haven't highlighted. Even if you depart from that received opinion, doesn't mean you're automatically in breach of your duty. If you can justify it, then you're fine. And this is the balancing act point. And everyone listening here will know about Montgomery and the fact that you're now under an obligation to provide sufficient information to your patient for them to be able to weigh up the pros and cons and make a decision themselves. And it's the same point here. It's the medical balancing act. For example, you don't want, a totally suicidal patient to come off medication if you consider, having discussed it with her, the risks of any teratogenic effect on the pregnancy is low. But as long as you explain that and keep a note, I'm sorry, just keep a note, because it is not that difficult. I mean, quite honestly, in giving evidence, and I'm not being unkind here, but in giving evidence, when Dr. Mitchell was saying to Her Honour Judge Coe, this is what my standard practice is, it took him about, well, I took a note of what he was saying. It took me about 1 minute to write down what he was saying. And in doctor's notation, it's not, you have got time to do it as a doctor. You really have. Discuss pros and cons. Decided that was more preferable for reasons given. Not that hard.
And as you say, particularly easy in something like folic acid where there aren't really any cons. It's just,
exactly.
This is what's recommended.
Exactly. Well, let's canter on, because we're probably people
away. We're getting to Coe's judgment now.
So this is the second judgment now, which is the one that's caused, as we know, this to come up above the parapet. And very simple factual issues. I mean, to be absolutely honest with you, I did not think this would go to a trial. It's the sort of factual issues and the reason that I didn't think that is that, as you will see, that the doctor's note was just, the judge accepted it was absolutely inadequate. So the issues that were to be decided, and here's a mother who's coming along, she's taken the trouble to come to the doctor for preconception advice. That in itself was very unusual. The doctor accepted that was unusual. And really there was almost a sort of res ipsa point, almost a sort of facts speak for themselves. If a mother has come to you asking for preconception advice, and you then say you've given her the correct advice, why didn't she follow it? You see, there's a sort of circular argument on the facts that was, I think, not very helpful for the children here.
And the bullet point about was she already pregnant? That's someone's raised a question in the chat saying, and I seem to remember this myself from having had a child, that knowing the sort of the alleged science of when someone was conceived and what day they're due to be born. Not so much of a science as complete guesswork. So how was that dealt with in the case?
And that was factually dealt with on a very simple basis, because mother's evidence was supported by father. What they had done once she'd come off the contraceptive pill is they just refrained from sex altogether. So there was no question. It wasn't a question of it could have been a sexual intercourse prior to the consultation, but with conception afterwards. But the occurrence was not dependent upon the negligence. This was a point that went nowhere, although a lot was made of it with dates and timings, etc. Because on a factual basis, as soon as the judge believed the parents that they had abstained totally, that was proven. I agree. In any other situation, that could have been a very tricky one. So another layer of defense, frankly, for the defendant doctor.
As you say, when it fits into a whole narrative of I actually went to the doctor purely for the purposes of obtaining some advice about this very question, you can see why the judge believed that sort of whole account was
I agree. Well, I mean, we were lucky because you don't know which judge you're going to have. As we know in our world, we find out the judge who is going to try the case almost literally the day before, or a couple of days before. We have no control over who the judge is. And we could have had a judge who completely took against the claimant's parents, who didn't believe a word they said. So these things to some extent are to do with the way that the evidence comes out on the day.
So there are a couple of interesting questions that have come up. So one of them is obviously this is the scenario where someone goes to their GP specifically for preconception advice. And so it's not surprising that they're expected to give them the advice about folic acid and possibly other things like MMR vaccine and so on. But what if someone is attending the GP anyway? Let's say they've got an ongoing health condition that means they have fairly frequent visits to their GP, but they're never, and they never ask for preconception advice, but they are not offered the MMR vaccine or something like that. Is that just...
What's the reason they're going? They just got a sore throat?
I don't know. Yes, I think we've just got a frequent attendance.
No, I think you're okay.
Reason.
Yeah. I think you're okay. I think, if you come in, doctor, I've got a bad back or a sore throat.
Yeah. The doctor says, well, you're of childbearing age. Are you on folic acid?
No, you can't. You can't. And that is where the law actually is quite sensible. I mean, there has to be this containment of reasonable foreseeability. Yeah. So, you have to reasonably foresee that something that you're doing is going to cause the harm that eventuates. And
it's quite interesting thinking about it now as well. It was back in 2001, whereas now, I don't know how many people go to their GP to ask for preconception advice, but it sort of feels to me as though people are probably more likely to go and ask Google for preconception advice and see whatever the internet says.
Well,
and I don't know the extent to which, particularly in relation to something like folic acid, I can see where if you're taking antipsychotic medication or something like that, you might well go and speak to your doctor and say, look, I need to think about this very carefully. But if it's these sort of more run-of-the-mill things that, frankly, a lot of people are going to have heard of or know about anyway, or can easily, instantly find very clear advice about on any of the million baby websites and pregnancy websites that are out there.
Let's not completely dispense with the medical profession. They are very important, and I would think they would prefer their patients to come and ask. But remember that on the facts of this case, it was unusual in 2001. I suspect you're right. I mean, Dr. Mitchell implied it was unusual even to the present day. But she wasn't coming to ask about that. Remember that the impetus was she'd been on the contraceptive pill for a number of years. And she was most concerned to know, how long should I refrain from having sexual intercourse after I've come off the pill in order to, because that's all sort of slight folklore, isn't it, about how long you have to allow medications for some reason to sort of exit your body. So that was the main reason she came. And she was saying, I've also heard something, and she raised it. I've also heard something about folic acid. So yes, there's a lot of criticism of her, this silly woman that should have known. That's not really fair, because if you're coming specifically and you're saying, I've heard a few rumors about this, and I could go, you couldn't have gone on the internet, I wouldn't have thought then to find too much about it, but you could read about it in magazines and things. But here she's bypassing that and coming to the doctor. Why can she be blamed for that? She's doing better. She's going to the gold standard rather than taking some sort of anecdotal.
Yeah. And in fact, one of the questions that's come in, I think we're about to get on to, which was suggesting that as far as we understand it, folic acid was discussed according to the doctor's note, but that then takes us onto the facts and what the judge found had actually occurred at that consultation.
Yes, absolutely. And I mean, to be quite honest, you needed to be at the trial. I mean, Mother was relatively straightforward. She was cross-examined very skillfully, and the cross-examination certainly bamboozled her, let's put it that way. And the judge refers to there being sort of areas of silence where she was just unable to answer a question. But I'm afraid she did have the upper hand here for the very simple reason this was a unique situation for her. She's coming specifically to the doctor before having her first baby. And it's the sort of situation that you can understand the courts accept our submission, that this is likely to stick in her mind. It's something she's likely to remember. And unfortunately here we get the problem with this really poor note that Dr. Mitchell made. I mean, the only reference was folate if desired, which ironically fitted into Mother's evidence that she asked about folic acid, was made to feel she was being a bit old-fashioned because that's all in the past, and you don't need to take supplements now because if you have a good diet, it is in your diet. And this is quite topical because I've noticed that recently this is being promulgated again, that a lot of food has folic acid added, and that people don't need to worry so much. So we're almost going to go full circle, because certainly I wouldn't ignore it, even though it might be more sensible now. Maybe a doctor could say now.
And in your case, it was accepted, wasn't it, on behalf of Dr. Mitchell, that saying it might be fine just to have a good diet would have been negligent. So Dr. Mitchell didn't say, even if I did say it's a choice, the diet's good enough, that would have been reasonable. He accepted that wouldn't have been the right advice in 2001.
Yes, and he had to accept that. He accepted it in the witness box as well, because he hadn't even asked about the diet properly. He agreed. I mean, and he actually said it would be very difficult to ensure that you had sufficient, because you had to know exactly what the diet was. So he was decent enough, I think, and good on him to accept that, frankly, if he did not give what he said was his standard practice advice, it was negligent.
Yeah. So really, this recent judgment just boiled down to who did the judge believe about what was said in that consultation.
Yes, it did. It did. And I think that's, these are the facts that were obviously decided. And I think that's virtually, that sums it up. So I suppose in a way, this was going to be the damp squib part of the case, because it was, as you say, it's very factual. It was only to do with an assessment of effectively two witnesses with two competing stories, what lawyers meet day in, day out, what judges have to deal with all the time. But of course, the consequences of the decision have ignited these areas of concern. And I think we've probably covered quite a few of them. I mean, the length of time after the event, you know what, sometimes you cannot avoid that, particularly if you have child injuries, for the reasons I've said. If your child is brain damaged, then you don't have a limitation period, because the child, as you know, Tor, becomes a protected party, and it does not have what we call capacity. And therefore, you can bring cases a very, very long time after the event. That is, I'm afraid, one of the facts of life. And if you're a doctor, that's one of the reasons that keeping a good note is drummed into you at all stages. Doctors rush cannot. I think that's changing now, because I think when I see doctors and the computerized systems, and you can drag and dictate. You can just dictate your note. Sometimes doctors, I'm still sitting there if I ever go to the doctor, which is pretty rare, and they dictate it while I'm sitting there. Yeah, to do that. So I don't think that's a real excuse. We've dealt with folic acid not preventing. Yes, it looks like it's an assault on the medical profession, but it's no more nor less than the assaults where the medical profession has sadly failed the patient. And I don't.
It's very interesting, I think, because you've really clarified some of the sort of misconceptions, excuse the pun, about the judgment, and in fact the old judgment rather than the newer judgment.
Yeah.
But there's still this kind of philosophical / public policy issue burbling away there, isn't there, about whether this is too close to being a wrongful life case. And as you say, it's I'm not surprised you all thought it was a Supreme Court case, because it's a really difficult sort of problem. And I suppose the question about whether it's opening the floodgates or not, well, if it does, then eventually the Court of Appeal and the Supreme Court will look at it, and we'll get a higher view.
Absolutely. That's the final crumb of comfort, because it is effectively not the end of the matter. If another similar case comes along and the facts support the argument, this can go further. So there's the appeal, not this case, but the other.
Yeah. I'm just looking at the question and answer box. So there's a concern that it will make management of pregnant women more defensive and so on. I think as an outsider looking at this, there seems to be quite a lot of constraints on when this factual scenario that could give rise to this kind of claim can actually arise, because it's got to be preconception advice. Yes. It's probably preconception advice that you've asked for, not just you didn't happen to mention this thing I hadn't raised with you. it's got to be a child then born with a disability that is significant enough that they bother to go and see a lawyer, but not so significant that you could pick it up antenatally.
Correct.
Then you have to show that the information you were given wasn't good enough, and it doesn't have to be the information that you were given that was the same as the kind of gold standard. It doesn't have to be perfect information.
Yeah.
And then you have to show that you definitely weren't pregnant at the time the negligence happened, and you definitely would have delayed conception if it had been done properly. So there seem to be kind of a huge number of things that a woman has to slot.
Yeah, there's a number of gateways, aren't there, that have to be passed through. That part of the reason that I wanted to have this webinar is to allay fears, quite frankly, is to say, if you do your job properly, you don't have to fear the lawyers. We're not out there to try and wheedle in. This was in fact a pretty glaring case of a job not done properly, when someone had specifically asked for a specific area of advice and it was not provided with care.
Yeah. And we've got a couple of minutes. So I'm going to try and skim through the last few questions quickly. So the last question that's been asked is, why is it relevant that the disability wasn't able to be detected antenatally? And I think you said that's because if it was something that could have been picked up antenatally, you would then be running into the territory of saying, well, you could have had a termination.
Yes.
And that is that's the sort of territory that
you'd have the
won't get into.
Yeah, perhaps on the facts of this specific case, it wouldn't have made a difference, would it? Because on the facts of this specific case, because it was a preconception advice, if the parents had chosen not to terminate, even if it had been identified, I think the claimant would still have had her own direct claim, because it was as a consequence. What the claimant cannot say is, you should have terminated me.
Yeah.
So it's because it's this preconception advice, because the effect of the correct advice would have been a different genetic individual. So it's a very constrained arena.
Yeah. And there's another question about whether there are ramifications for prescribing medications to women of childbearing age that have an impact on, or could have an impact on a fetus.
Yeah,
but it seems to me that
cases, and I think you're right. Yeah, that would, but obviously.
But isn't that duty's already there, isn't it?
Yeah,
you know, I mean,
it's there already, isn't it? I mean, I'm just thinking. I mean, in fact, I don't think an individual doctor could ever be sued within the thalidomide litigation if it had ever properly taken place, because they didn't know the outcome of prescribing that particular drug, and it was the intention was beneficial. That's hence why that type of case, it tends to be an inquiry and a governmental system set up for some form of rather paltry recompense.
Yeah. And if you're in that territory of, well, this is a medication that has these benefits to you as the mother, it may have some impact on the child, but we don't really know. There isn't really clear evidence. You know, then you're in that territory of, well, you have those discussions, but ultimately it's a weighing up of risks. Whereas in your case, it's much more cut.
Correct. Then it becomes the mother's decision. Now, if the mother has received advice that there is a statistical risk that this could cause that, you know, that mother almost certainly, if she's asking for that advice, would then herself say, well, I'm not going to take that risk. Or alternatively say, I am going to take that risk. So by giving the correct advice, you move yourself into a position which is not unassailable, but you are more protected as a professional.
Yeah. Yes, and I suppose in some of those medication cases, the other interesting thing about folic acid is you just take it prior to conceiving. Whereas, so you can just choose to do that at a particular point in time and then conceive. Whereas if it's a medication that you take routinely for your whole life because it's required for a health condition that you have, there isn't that same black and white choice between conceiving this week or next week, having spent 3 weeks on the medication. You know, it's a different, the sort of risk benefit, and the decision-making process is completely different, isn't it? Yeah. All right, we have to stop soon because we've managed to take up our whole hour, but we've, I think, answered at least some of the questions, if not all. Probably not all, but some of them. And if you've got a burning question that we haven't answered, then if you've got either of mine or Susan's email addresses, which you can probably find on the internet or on Twitter, just feel free to email us if you would definitely like us to try and answer it. These slides are going to be available, and the recording will be available on the Chamber's website. So again, if you want to have a look at the slides, I think they will go back and answer some of the questions about what this case was really about was the timing of conception and not the link between folic acid and spina bifida. But from me anyway, thank you all for attending. Thank you, Susan, for being roped into doing this explanation, at least half for my benefit and hopefully for the benefit of everyone else who's been listening.
That's very kind. Tor, thank you for putting your head into the lion's mouth effectively. Thank you everyone who's attended, and we will seek to answer questions. We are very concerned to get the correct answers out there, so we will do a little podcast if needs be. Thank you. Bye-bye.